Thank you. Good morning. It seems it's going to be a distance education session because it was David who said that after the third row it was distance education. So, okay, here I am to talk to you about the legal aspects. So I always have this feeling that after so many interesting talks, I'm going to be the party spoiler. Here comes the lawyer with the boring stuff and with all the problems that are not solved and that are, hindering us from doing what we want to do. I hope I'll be a little bit not so gloomy, and I hope to bring some hope, but let's see. So legal issues are usually presented as the challenges that need to be solved and overcome so that we can do what we want to do in OER. But I would say, let's not take it as a problem, but let's take it as a challenge to make the world better. Law is a very important part of our world, and we should not leave, giving our backs to it. So if the law is not fit to what we want to do, let's change it. Let's do it. We're enough to do it. Let's try at least. So what legal issues are we going to talk about? First, IP, of course, but if you allow me, I will save it for the last because I know it's the ones you want to talk about and it's the ones that are raising most of the problems. But also other kind of legal issues. There's image rights from professors who are being recorded while they do their lecture, and then the lecture is posted online. I was reading the other day about an experiment or a project that Yale University is. Do you listen? Is it okay? That Yale University is gonna be doing as of next year, of posting the lectures and the related material that the Yale professors are doing, posted them online as part of this OER project. So the professors have some saying in, allowing the institution to put their lectures up there. Privacy concerns also from users. I know that all OER platforms are interested in knowing what their users do while they are accessing, the repository or the portal, as in the open courseware. So even if it's access or registered access, or if it's free access, but there's still some cookies that are missed in place so that, the institution or the platform can know what the users are doing to improve what they offer and the way that you navigate. These may pose some data protection problems. We know what this particular user, be it a student or a teacher, likes to access. It might be religious stuff. So there's all this information that it can be derived from the user's, navigation through an OER platform that might be subject to personal data protection. Another legal aspect that the institution or the platform should have in mind, competition law. Depending on how we address the openness issue, we might have a different de facto power among different OER platforms. And this might pose, and this is may pose, some competition law concerns. We're not there yet, because so far it's only a few institutions that are doing it. But imagine if we end up in a world where OER is de facto, I'm not going to say legally, implemented by just one, but de facto is just one platform that's there. What are other chances of other platforms coming up? It's all the market. Another problem, that legal issue that should be addressed, or at least bear in mind, government information. Many of the OER, the contents that we put up there, might be related or might be using government information produced by administration, be it weather forecasts or statistics data of any kind. And this is a very important thing because in the States, data, information produced by government agencies is not protected and cannot be subject to any access or use control. This is not the case in Europe. In Europe, there's a directive which allows government agencies to condition access to public information, to data. I'm not talking about works, I'm talking about data, pure data, facts. So in Europe, this access and use of information may be subject to conditions by the government, right? So this is something that we should bear in mind, because something that is freely done and used in the States maybe might not be so easy to do in Europe. A sixth almost legal issue that we should bear in mind, ISP liability. In one of the previous sessions, somebody said, oh, we don't worry about any infringement going on within our portal, because after all, it's the author who's responsible for any infringement. Well, I wouldn't be so sure about that. The platforms, be it a portal, be it a repository, is acting as an intermediary over the internet. Actually, they are hosting contents. And in that sense, both in the States and in Europe, there's regulation addressing what might be the responsibility, the liability of an intermediary, what we call an internet service provider, ISP to make it short. What might be its responsibility for the infringements committed by their users. And we're not only talking about copyright infringements, they might be the easiest to find, but think of defamation. Think of, you know, the experiment or the case that happened in the States with these at the OpenCourseware, that they, you know, reacted by removing the sites when there was all these hate messages going on about this Japanese, Chinese thing. So in principle, if according to this, so these intermediaries might be liable for the infringements committed by the people who put the content online, by the author, by somebody who's in a chat group and is talking about something, and this chat group is hosted in one of these ISP, one of these portals. Okay, general liability rules that may be different depending on each country. And this is another issue we'll tackle at the end. But in order to make things a little safer, to bring some certainty into this messy internet world, both the States and in Europe, and I'm not aware of any other regulations, so I'll be most of, you know, talking about these two and comparing. Both in the States and in Europe, there is provisions stating some safe harbors, what's called safe harbors, which means that if this intermediary complies with certain requirements, certain conditions, it will not be held liable for the infringements committed by their users. It doesn't mean that if they don't comply with these certain conditions, they will be held liable straight. They'll have to go to court, and the judge will decide who's liable for the infringement. The person who put the work up there, or who wrote the words that are a defamation, or the institution, the intermediary who's holding the platform. One of the things that the intermediaries should be taking into account is that it's what's called the actual knowledge, the awareness test. What in the States is called the red flag test. We don't say it like that in Europe, but it's the awareness of knowledge test. The ISP doesn't have to be controlling what's posted, what he's hosting in their website, but as soon as he's aware of some infringement or some crime going on, aware of things that make it apparent that there's an infringement, not only suspicious, but it sort of looks like there might be an infringement going on, he should remove the contents. If they remove the contents, he's not liable. If the content is up there and remains up there, despite the ISP being aware that it might be infringing, then he might be liable. The ISP might be liable for that. I'm not going to bother you more with these ISP liability issues, although they are very interesting, and there's a lot of differences between the state and Europe regulation. In the States, the liability, the ISP is only exempted from liability for monetary damages. In Europe, the ISP might be exempted from liability also for criminal offenses. The funny thing in this in this area of ISP liability and in all the other legal issues that I was jumping up from one to another, is the problem of territoriality of our laws, the problem of applicable law. The laws we have, and that we will probably keep having for centuries because nothing is moving in that sense, are territorial laws, are made and used to be enforced within the territorial borders of our countries, of each country. In internet, anything, any act, any infringement, any act of defamation has effects worldwide. So there is no international consensus as to which law should apply to which acts. There's this big conference called the Hague Conference on Private International Law. These are issues of private international law, that's what we call it. And they have been trying for years now to come up with an agreement as to which law should apply to what. For instance, if there's an infringement on a website posted in an ISP or hosted in Spain, should Spanish law apply to all the acts, infringements or not? And that's what the Spanish law would decide, that are committed, that are done on this website, regardless of where the users are that download these contents, regardless of where the person who put up the contents was when they put up the contents. He may be in Barbados and sending it and putting it up, you know, from whatever. So there's no agreement on that. And what usually courts do is they apply their own laws. So if you go to a Spanish court to claim something that has happened, an infringement that has happened on a website posted in Germany, hosted in Germany, Spanish courts may end up applying Spanish law, because that's the law they know. And they say, okay, you can access it from here in Spain. So the infringement was committed in Spain, no matter where the website is. So that's a Spanish infringement, which will be decided according to Spanish law. This is terrible. This creates a lot of insecurity because you might be a very careful portal, and you may say, I'm going to try to comply with the law. So I'm going to see, for instance, in terms of copyright, I'm going to see if this is fair use or I need a license. I'm going to see if this is, if this particular comment I can make according to Spanish law because it's free speech, or if it amounts to a defamation because it is something I, could be sued for. Regardless, even if you do that, you're careful according to your law, you may end up being sued somewhere in the world. Remember, there was this funny case, so that I don't talk about copyright, there was a very interesting case about a journalist, a British journalist who was writing for a British newspaper online, and he made some comments about the dictator in Zimbabwe. And the web page was posted was hosted in a British server. It was a British newspaper, but according to Zimbabwe law, that was a defamation. According to British law, that would be free speech, right? But so the guy is being sued in Zimbabwe, although he has never been in Zimbabwe and will probably never be now. But this is not funny because it's a really terrible world out there, but this is one of the trickiest issues over the internet concerning legal issues, and the one that has no solution. And it doesn't look like it's going to have a solution soon. So now let's move to IP issues. I just picked up some flattering comments about IP that was being said, and I read on the debates and the documents, such as this one. It's the thorniest. Open licensing is one of the most confusing and difficult issues associated with OERs and could make or break the open content movement. And that's the one I like the best. Copyright is the root cause of slow development in this field. So what I will try to explain in the half an hour I have left, because I got very slow, is why copyright is not thorny. It's wonderful. And why it's not the cause of all evil. Everything that goes wrong in the world is not because of copyright. In fact, I see there's ground for some legal changes that we should attempt if we want to make the OER to succeed. And then perhaps bring some issues about legal of licensing, and especially open licensing, among them CC licensing, that it's simpler than what people think, but we should all make an effort to try to separate, you know, the mumbo jumbo from the real things. We should all be aware of what we're licensing, what the user is getting, and try to avoid confusions or things that go on and that doesn't make it easier to understand it all. So, IP. Well, when we talk about IP, we mean very different things. We talk about copyright, of course, but also trademarks and patents are IP issues. Patents are very difficult to obtain. It's a very strong monopoly. Almost there's no exception. There's no point of somebody else using a patent without the patentee, the patent owner authorization, but it's very short-lived. It's only 20 years, and that's it. You cannot renew it. Trademarks are easier to obtain. You just register, but they are limited to the product or the service within which the trademark is being used. And within a market, usually it's territorial markets, patents, trademarks are fragmented. But still, they can be used and renewed forever. Copyright is very easy to obtain, very easy. You just create and you have a copyright. But to compensate that, it's not a strong monopoly, no matter what people think. There's a lot of exceptions that the law allows people to use a copyrighted work for certain specific purposes, because it's thought that there's a public interest somewhere that should be balanced against the private property of the copyright owner. So all the exclusive rights are somehow balanced. We may enter into this discussion if the balance we have is okay or not. We can get into there. And it's not forever. Copyright is limited in time. We may also discuss if it's enough, if it's too long, but it's limited. Not as limited as patents, but it cannot be held at perpetuum as trademarks. So when we talk about IP issues within the OER movement, it's basically copyright we're referring to. Nobody is complaining or saying that there's legal problems with IP issues concerning the name of a university being up there with an OER. On the contrary, we think it's an added value. Or the name of a platform. This is trademarks altogether. We're not also dealing with patents or anything that has to do with you know, patented inventions. So it's basically copyright. So now let me be provocative. All these IP systems, especially copyright, serve one only purpose. And this is something we have forgotten. It's the public interest. It's the common good. We live in a world where copyright is something that only, you know, applies to greedy industry people, and the authors are trapped in this industry thing, and we, the users, have to be enduring copyright because it's a monopoly. And no, the purpose of copyright is to promote creativity. And I really love Article 1, Section 8 of the US Constitution, a constitution that was made, what, 200 years ago, and it's still there. And it's a very progressive, has a very progressive clause about copyright. It says, Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. So, to promote the progress of science and useful arts, this is what copyright should be achieving, and we should expect copyright to achieve this good. So that's one of the things I wanted to post for, you know, debate. Before we turn and we focus on licensing, let's also see if the law really attends what we need for and what we aim for. I know it's difficult to defend public interest when we're talking about a private monopoly and a bunch of exclusive rights granted to the author, but there's boundaries to property, as with any private property. There's boundaries to copyright, and we should see that these boundaries are the ones that promote creation. So what can copyright law do or not do for open educational resources? Copyright is a monopoly because it's a bundle of exclusive rights that the law grants to the author, and the author is the one who creates. The law doesn't grant any rights to the producers or the industry. The law grants rights to the authors. Which rights? reproduction, distribution, communication to the public, and transformation. Usually it's these 4 rights we're talking about. Reproduction means making copies. Distribution, well, there's some things that Europeans and the US don't get along too well on this issue, but in European terms, distributions means making public, tangible copies of the work, putting them in the market so that users, consumers can get them. Tangible copies has to do with distribution. Communication to the public means everything that allows the work to reach the user, reach a society without any tangible copy in between. Radio, TV, movies being shown in theaters. Online distribution. Distribution, that's the American term. And transformation. Transformation is allowing the making of derivative rights. These are exclusive rights. Why exclusive? Means the author can authorize and can prohibit. Which means that sometimes the author can abuse his right by prohibiting something that we should all be, happier if it was authorized, because there's no reason to prohibit such use, but still the author prohibits. That's what the law empowers him to do. Not only to authorize, but prohibit. But as I was saying, the monopoly is not limited. There's specific purposes to which users can use rights without the author's consent, without the author's authorization. It's limited in time. And it's limited as to contents. Not everything is protected, no matter where we put the CC license on. This may not be a work. A work is protected under copyright when it's an original creation, right? And we don't need any registration or nothing. Facts are not protected. Ideas are not protected. Information is not protected. The way I express this information is protected, but not information per se. So the monopoly is very limited. It's only a monopoly upon the expression, not the contents of the expression. And that's one of the beauties, that's one of the things of copyright, how to distinguish between expression and the ideas, the content that underlies this expression. What's important to bear in mind about what we call exceptions, one of the strongest limits of copyright, is that education has always been an exception to copyright, educational purposes. And that's where I think that we should strengthen, we, the OER movement, should be focusing to make these educational exceptions stronger. The Berne Convention of 1886 already conveyed for an exception for educational purposes. 1886, a century ago. And the current the Berne Convention is like the macro international IP protection treaty, okay? It's dated in 1886. So educational purposes are there as a public interest that justifies an exception, a limit to the author's copyright. The author should not have a power to authorize or prohibit educational uses. What happens is that over the years, this educational exception has turned into a teaching exception. And now, in this recent European InfoSoc directive, we call it the Copyright Directive for the Information Society, 2001, implemented this exception and doesn't talk about education, talks about teaching. So teaching is very much limited to what goes on in a class, maybe a virtual classroom, because in that sense, both the Berne Convention and both the European Copyright Directive are aimed at allowing teaching uses freely, without the author's concern. Maybe also for free, they don't say anything about payment or not. For teaching purposes, online, both the Berne Convention and the directive are clear. The problem is that neither the Berne Convention exception nor the directive exception is mandatory for member states. And what do member states do? Nothing. So when you go down to national laws, there's still very little exceptions for teaching purposes within the copyright laws. And this is something we could all be working on from our different perspective. Make sure that in the copyright laws there's an exception, at least for teaching online uses, that could allow for professors to use material, works from other people for teaching purposes online. And then, once we have this, we may discuss whether OER qualifies as teaching. Because it's very easy to say, when I teach the students and it's access protected, you know, password protected, and it's only the students who have access to this site, that's easy. But what we are doing here is putting these educational materials that will be used for teaching or for self-learning online. But still, it would be a first step that I think we should not forget. So what has happened in recent years? That copyright law has been expanding. It has been expanding more in the States than in Europe, because the States had this little problem with the term of protection. The States was only joined the Berne Convention in 1989, 100 years after it was passed. The Berne Convention is the one that says that the term of protection will be based upon the death of the author, and it sets a term of 50 years. In Europe, we have a term of 70 years after the death of the author. In the US, the term of protection was based upon publication. So the terms were shorter than in Europe. What happened when they accessed the Berne Convention is that because of a specific provision in the Berne Convention that says that the works will be protected in other member states according to the term of protection they have in their country of origin, what happened to the States, to the American works, was that they were getting less protection in Europe than the European works. So they decided that they had to extend the term so that their works were protected in Europe for as long as European works were being protected. So in that sense, the American have, they have been suffering a larger extension of copyright laws than we have been suffering in Europe. But in general, it's true that what used to be a monopoly aimed at exploiting works, exploiting meaning commercial and within the public, has turned into a monopoly for controlling the use of works. Within the new definitions of reproduction and communication to the public that the laws have enacted as a result of digital technology, every use, every reading of something online becomes an act of exploitation subject to the monopoly in this good sense of the author. So it's true that now copyright covers it all. And the pity of it all is that it has not been counterbalanced by a strengthening of these exceptions, a strengthening of these limitations. On the contrary, in the States, they have suffered an extension of, or a diminution of the limitations because they have enlarged the copyright term. So all these is sort of like the backstage for the open licensing movement. The idea behind is that we are going to rebalance copyright law by means of the authors giving back to the public what the law is empowering them to do. If the law is not balanced, let's authors bring the balance. And this is what the open licensing system is all about. But before we go into the, how many time I have? 15 minutes I should have? Half past? I talk too much. Anyway, before we go into the CC licensing, which is I'm sure what you are all expecting, and we just get our teeth on it, let me just mention one little thing, the allocation of copyright ownership. I was saying that these exclusive rights are being granted to the author, which means that OER movement should be always considering the teacher or the author, professor, the author who creates this material should be the one licensing or authorizing, not the institution, the author. But there's some exception to the author being the first owner. One of them is works created under an employment contract. What in the States is called a work for hire, and in Europe we call work created by virtue of an employment contract. When there's an employment relation and the work is created as part of this employment relation, and this should be specific, the first owner, not the author, but the owner of all copyright goes to the employer, not the employee. But even if there is an employee-employer relation and the work is not part of the employee's obligations, he retains the copyright. So in order for the institution to be able to license something, there should be a contract, there should be a license from the author, even if he's an employee. Another category, commission works. Works that have been commissioned to do. In our university, remember Lloren's advice, the rector was telling you that we have commissioned all our materials because they've not been written by the professors, but by third university professors. So we commissioned all this material and we have a license with them. In the States, if you commission and you agree both parties by a written instrument that this qualifies as a work made for hire, all rights go to the commissioner, the institution. In Europe, there's nothing like that. There is no rule that says when you commission something, the rights go to the institution. So if you don't make a good contract, you will end up having nothing. We might end up paying for something. So what happens now with the UOC? To go back to the example I was putting, that most of our contracts that we had were licensed at a time where we were not thinking of OER. We were not even thinking of putting the materials online. So most of our contracts deal with reproduction and distribution in paper format. So now, if we want to go OER, we have to bargain, renegotiate all these contracts, which is something that can be done, of course, but it's an added, a trouble to deal with. So, good contracts are very important from the very beginning. So now let's go to CC licensing. It's simple. They work very simple. The author chooses what license he wants, and when he posts the material online, he attaches the license. The license is, I tell you, I'm not sure I tell you, I'm quite clumsy with PowerPoint, so I didn't even dare to make one. All right? Let me see. That's what I want. So I'm going to save you from the PowerPoint thing because I'm one of these persons that crams everything in there and then you cannot read it. But I promise to, post it published in Word format or whatever, so you will have what I'm saying. So it's simple, it's hip, it makes you feel good, and that's a very important thing for its success. The author has the ability, what we were saying, to give back to society what the law empowers him to do. So he simply needs to choose which license he cares, post it online, attached to his work, and the user knows what are the conditions the author is licensing his work to be used and reused. So, and this is an important thing to do, to bear in mind. As soon as a user reuses the work, he becomes a licensee, right? It's a contract between the author and the users that will eventually reuse the right. So the author never gets to know the other contracting party. Maybe eventually someday they'll meet in court or they'll fight over something because they didn't agree with the way the work has been reused. But from the beginning, the author knows that he is licensing very many people around the world that he doesn't know. That's something weird for contracts. And in fact, I was hearing that in the States, these CC licensings would never qualify as licensing, but as waiver of rights. In Europe, they could qualify as licensing, but that's technical legalities. I'm not going to bother you with this. So, all licenses are shown in 3 levels to make it easy to read. The commons deed, that's the symbols that we all know for people to read. for humans, it's the legal code for lawyers, and the digital code for machines, so that the search engines can find which works have been licensed. It's always very funny to see the lawyers don't qualify as humans or as machines, but so I don't know if it's good or bad, but it's really something nice to say. So what's the basic license? The basic license authorizes, the first one, authorizes reproduction, distribution, transformation, communication to the public in any means, any format, for commercial and non-commercial purposes, for free, meaning without money, forever. The author can narrow down based on two things. He can exclude commercial uses, and he can exclude the making of derivative works, transformation. And if he chooses not to exclude the making of derivative works, there's a third subcondition he could make, which is to subject subsequent derivative works to the same license he has granted originally, right? So condition subsequent uses. So all these combinations have as a result these 6 licenses. Attribution, attribution no derivative, attribution non-commercial, attribution no derivative, no commercial. This is the narrowest one. The first one, the attribution, is the broadest one. Attribution, share alike, that's the copyleft clause. Share alike. The author is determining the conditions upon which the new author will be exercising his copyright. This is something very interesting for copyright lawyers, because we used to think of the author as the queen, the author as the king of deciding what to do with his copyright. Well, with his share alike clauses, he cannot decide what to do, because he has to be doing the same that the original author commission authorized him to do. So altogether, the copyleft, the strict copyleft is only these 2 share alike attribution clauses. Not all CC licensing are copyleft. It's another thing that we should also be aware of, terminology. So who can grant a license? The author, not the producer, not the institution, just the author. In some countries, artists may also grant licenses. Imagine you're doing a musical work and you're not the author, but you're interpreting something, or you're playing, you're a musician, you play. You could not grant a CC license in Spain, because in Spain, that's one of the things that probably you will be addressing soon. So far, it's only authors who can do it. In other jurisdictions, artists, musicians, singers can also grant licenses. Producers could also grant CC licenses, not in Spain. A thing we should be aware of is that the CC license, when the author grants a CC license, there is a prima facie statement of legality. We think that the author is the one who can grant his license, right? When we see a work that's being CC licensed, we don't assume, oh, maybe he was not the author who was writing it. So we all take it for granted that there has been no infringement in the posting of a CC license. But I'm not saying that the CC licensing should be, granting any registration rights or anything like that. No, I'm just saying that we should all be very aware of that, because I have sometimes run across authors who say, if I put a CC license, this means I'm registered, right? No, CC licensing is no registration. There's copyright registries to have the work registered. And this would be an evidence that somebody should prove contrary to, revoke your right. Registries do grant you a prima facie right. CC licensing does not. So this is something we should be aware of. On what do we grant CC licensing? On works, and only works. I've seen CC licenses granted on something that's not a work. So then, there should be no licensing. People wouldn't need a license to use something that's not protected by copyright. For instance, one of the things I'm really blows my mind is why blogs have all this fixation with CC licensing. It's like, if I do a blog and I don't put a CC license, nobody's going to be able to use it. Well, why not? I mean, it's like conversations. Did we used to Whenever we have a conversation with somebody else, am I saying you're allowed to use it because this is copyrighted? So we have to be also very careful with these misunderstandings that if we don't CC license something, we cannot use it, right? Moral rights. Attribution. Why attribution is so important? Well, it's important in the States because they don't have an attribution right in their copyright laws. It's not as important in Europe because regardless of no attribution being in the CC license, anybody who uses somebody else's work should be attributing, should be giving credit. But in the States, there's no moral rights for all kinds. There's moral rights for specific works of visual art, they call it, but not for general works. So from an American perspective, attribution is a very good way to enforce attribution is by means of a contract. That's why we have the attribution here. There's nothing about the right of integrity, but the right of integrity means the right to oppose any distortion of the work that is detrimental, that is prejudicial for the author's reputation or honor. CC licensing doesn't say anything, but it doesn't mean that the author is giving up his right of integrity at all. I mean, the right of integrity, at least in Europe where it's protected, derives straight from the law. So no matter how many CC licensings the author does, either one or the other, either allowing derivatives or not, he could always sue one of the license users for having modified the work in a way that is prejudicial to his honor or reputation. So it's not like the authors are waiving his moral right of attribution. Exploitation rights. Well, as I said, all of them are covered. But there's three factors that we should all bear in mind because they don't show in these icons. And there's three factors that are implied in any CC license, whichever we choose, and the author cannot, move them or exclude them. The for free, it doesn't mean that the author cannot make a remunerated copyright contract with a publishing house or a producer. It's just that if he finds a publishing house or a producer who wants to, pay for something that everybody can get for free. But it simply means that the uses that he's granting will be for free, and he cannot ask for any remuneration. All means of exploitation. And this is also a problem of interoperability between jurisdiction. All means of exploitation in the States may mean also means of exploitation that now we don't know. In Europe, this would never go on. I mean, means of exploitation is only the means that we know at this time. So if something as important as the internet, that's not the internet, but something comes up, a new means of exploitation in 10 years, any CC licensing that we have been granting now will not cover in Europe, will not cover these new means of exploitation. In the States, it may cover these new means of exploitation. So this might make also bring problems of interoperability. And the third clause that it doesn't show, it's forever. The author can decide to say, no, now I don't want to, I'm going to retrieve the work, or I'm going to change it and put it under another license. It's true. But the licenses, the uses that have been done under that license will remain, will go on and on and on, especially if the derivative works were allowed. So it's forever. This is something that Ignazi and I are always discussing about and never reach an agreement. So what are the options the author can make? The options the author can exclude or decide to put in there. He can exclude transformation right, and as I said, put it under a share-alike clause or not, if he allows not to exclude transformation. And he can exclude commercial uses. And there's this big debate going on as to what's commercial, what's not commercial. I know the CC licensing are doing, the Creative Commons are doing some guidelines, working on some guidelines to see, to help people understand what's commercial or not. It's very easy when there's a private compensation, a monetary compensation. It's very difficult when the compensation may be indirect by means of ads on the webpage or something like that. So we'll have to wait for these guidelines. But what's important is that what I was saying, no matter what the license say, the law prevails upon the license. The license is just a tool between two people. But if the law allows you to exercise your integrity, moral right of integrity, you can do it no matter what you have licensed. If the law allows you as a user to make quotations, to use works for teaching purposes, to use works for informatory purposes, to use works in official ceremonies or whatever, there's a bunch of exceptions that we have in European laws. All these uses we can make regardless of what the CC license says. And this is a point that I would like to stress about that Dutch case that happened, a Dutch court, Corrie case was the name? Adam Corrie. He's a famous Dutch person. I don't know why he was famous for. And he put some family photos on Flickr with a CC license, which was non-commercial. And there comes a magazine, an editorial, or a journal, a tabloid, that's a good word, and uses some of the pictures to convey some news about this guy. So he sues, and he won the case on a CC license because the judge says the author excluded commercial uses, the tabloid has made a commercial use. Well, very nice, we're all very happy. CC license being enforced in court, that was something that at the beginning everybody was afraid. But now let me turn it around, and I'm gonna be provocative here. Despite being a commercial use, wasn't it informatory purposes? We have an exception in our copyright laws that says that people can use works for information. So maybe it was allowed by the law. So what we have here is like the reverse of what we wanted to achieve. We wanted to achieve people could use works freely, and at the end we are enforcing licenses for something that might be reducing the scope of allowed uses under the law. It's a very extreme example I'm putting. I'm just, making it for comment, but I wouldn't be surprised if we just focus on the license, that we might be using some uses that, might be already allowed and don't need to be licensed. On the contrary, the license may reduce that. I think I should stop because I'm just being a pest, and maybe we should open debate. There's very many issues that we could be talking about the CC licensing, but I think it's better if we just make questions and we try to debate, because I'm a plaster and I don't have a PowerPoint, and it's really hard to keep attention. So just two ideas. One is that users should know, we should as institutions or whatever you are, right? We should be very aware to convey good information and try to separate what I call the mumbo jumbo from the reality. CC licensings are a great tool. I heard somebody say it's a toolkit. It's a toolkit with a specific purpose to restore balance within the copyright law. It's a great experiment. It's a great experiment, as many others are in the market. This is the most successful, but it doesn't mean there are other open licensing systems around. So it's a toolkit to get a job done, and it's getting the job done. But it also has some pitfalls. It also has some things that we should be careful about, because we don't want to end up where we didn't want to go, which is reducing or sort of, avoiding, or let me put it this way. It's difficult to live in a world with copyright. It's more difficult to live in a world with licensing all over. Trust me. Sometimes the law is our best ally. And that's why I think it's good that we focus on licensing, because it's a way to restore this balance and get things done fast. But we should not forget that the law is there, and that there's also, if copyright law was aimed to promote creation, to promote public good, we should not forfeit it. We should just go back and demand that the law does do that, be it through exceptions, whatever. There's these very interesting international movements going on. The WIPO is debating a treaty on a development agenda, There's a treaty that has been proposed on access to knowledge. And it's not only referring to developing countries, you know, so that they can make translations freely, but also, you know, to the developed world. And education is there, and education is one of the main, you know, public policies that should be enforced against copyright. So I think there's still a lot of room to maneuver within the law that we should not be forgetting. And let's leave it here.